I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on state open meeting laws. As a reminder, all of our classes build off one another, so if you haven't already, please view our previous lessons on open meetings and executive sessions. They'll give you a good overview of the law and lead into what we'll be discussing today. We also have a growing library of lessons on state public record laws and the Federal Freedom of Information Act. All these lessons can be found on our YouTube channel, as well as in our FOI guide at nefac.org/FOI guide. Before we begin this lesson, a special thanks to those helping us make these classes happen. The Society of Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition, and I want to thank you all for joining us for this webinar, which is brought to you by NEFAC. This session is going to focus on open meetings in Massachusetts, and with us is attorney Ruth Bourquin, and she is a senior and managing attorney with the ACLU. Ruth, thank you so much for being here.
Thanks for having me. Hey, hello and good afternoon, everyone. I was asked to talk about free expression and public comment periods in Massachusetts, which is really good timing for this program because our Supreme Judicial Court issued a very important decision on this topic just a couple months ago. As a lot of you may be aware, across the country, there have been questions arising about when public officials can silence people during public comment sessions at public meetings consistent with the First Amendment. And this issue has come to the fore more as we've seen some of the culture wars come to public meetings where people have been very energized about topics they're raising for school committees and city councils, et cetera. There was an article in the Washington Post this past winter that sort of surveyed some of the landscape and talked to some of us in Massachusetts about it. So, and that was before the SJC decision. So again, I think this is a timely topic for discussion. Start with just some really basic principles. What are public comment periods? There's a fairly long history of most local government bodies providing opportunities during their public meetings for members of the public to give input. And these can either be separate periods just called public comment or public input periods, where members of the public can bring up any matters generally within the body's jurisdiction, or they can be periods during the agenda portion of the meeting where people are given an opportunity to comment and ask questions about that portion of the agenda. Generally, these public comment periods are set for an overall period of time. And then within that, individual commenters are generally given maybe 2 to 3 minutes to state their views, and then it's the next person's turn. You can go to the next slide. Under our state open meeting law, which is General Laws, Chapter 30A, Section 20G, there are provisions that have caused some confusion. And that section generally says that no person shall address a meeting of a public body without the permission of the chair, and all persons shall, at the request of the chair, be silent. That's one of the portions that have created some problems. Going on, it says no person shall disrupt the proceedings of a meeting of a public body. There's also been questions about what does it mean to disrupt the proceedings of the body. And then if after clear warning from the chair, a person continues to disrupt the proceedings, they can be ordered to leave the meeting. And if they refuse, someone will escort them out, usually a police officer. So a lot of questions arise under that language, and many states across the country have very similar open meeting law provisions. The next page. In particular, as I pointed out, the part about the chair being able to silence people has created a misimpression that the chair can tell people to be quiet anytime, even after they've been called upon to give their 2 or 3 minutes of comment. Whenever the chair just doesn't like the substance of what people have been saying. And we have taken the position for a long time that that is an accurate reading of the language, which has to be interpreted and consistent with constitutional free speech rights. We have seen lots of examples of chairs telling people to stop talking, stop their comments because they've mentioned members of the public body by name in a critical way. They don't ever seem to really mind when they're being praised, but when they're being criticized, they often react to that and say that people are not allowed to make personal attacks or be rude or not courteous, etc. And what we have perceived, and others have too, that these rules have often been used to stop members of the public from criticizing the performance of their public officials, which one might think, and as we'll discuss, our SJC thinks, is in fact the point of having public comment to a substantial extent. So we have been concerned for quite a while about how these provisions of the open meeting law have been used to justify silencing people based on the content or viewpoints that they're expressing during the public comment periods. In fact, we did a lawsuit back in 2018 and 2019 against the Natick School Committee for silencing people for giving respectful but critical commentary during their school meetings. And the Superior Court ruled in favor of our clients. And as a result, the school committee very appropriately amended their policies to conform to free speech principles. And that's been in effect for quite several years now. Then enter 2022, and a very similar case reached the Supreme Judicial Court. It's called Barron versus Calenda. And there, a resident of Southborough, Mrs. Barron, was silenced after she was called upon to present public comment at a select board meeting. She wasn't just heckling from the crowd. She was actually called on after waiting her turn. And she calmly stated that she thought that the board of select persons in Southborough, one, was spending too much money, and two, had a problem with violating the open meeting law, which, as it happens, the Attorney General's office had found repeatedly that they had. The chair ordered her to stop talking on the alleged grounds that her comments were slander and that violated their policy. And she objected and said that the chair was being a Hitler. And the chair then ordered her to leave the meeting after yelling at her for a while, or she would be physically removed. Not surprisingly, she sued, and her claims were ultimately presented under our state constitution as opposed to the First Amendment, asserting her rights both to freedom of speech and freedom of assembly. And the Superior Court, who originally heard the case, dismissed it, saying that her comments could be silenced because they disrupted the meeting, even though she stayed with it. She was called on. She stayed within the time she was allotted. She didn't do anything to interrupt anybody else's proceedings. She was in her allotted time. And but the Superior Court found that the town's policy, which prohibited rude or personal or slanderous comments, was perfectly lawful. The case then was appealed to the Supreme Judicial Court, which asked for amicus briefs, and we filed one. The ACLU filed a brief, including tracing the long history of public comment sessions in Massachusetts all the way back to the colonial days, and arguing that the lower court was wrong, and the Southborough policy and the Superior Court decision both violated the state constitution. Then on March 7th of this year, the SJC issued this very important decision, we think, agreeing with us that the Southborough policies and other like it are unconstitutional under both Article 16, which is the free expression, free speech provision, and Article 19, which is the right of assembly provisions of the Massachusetts Declaration of Rights. And in its decision, the court ruled that any content-based restrictions on public comment at public meetings are subject to strict scrutiny under the state constitution, and that rules that allow the silencing of criticism of public officials are unlawful, including because they're viewpoint-based discrimination. The court also went on to rule on a couple issues relevant to whether or not the chair likely violated the Mass Civil Rights Act, and they ruled in Ms. Barron's behalf on those elements as well, finding that if the facts were as alleged, the chair engaged in threats, intimidation, or coercion by threatening to have Ms. Barron thrown out, and also would not have been entitled to qualified immunity because these principles were clearly established. So in the wake of the Barron decision, I mean, first of all, there's a lot of press that a lot of you are aware about the decision and about the fact that the court specifically ruled that rude comments are allowed in public comment sessions. And that is in fact what the court ruled, because Southborough's policy did forbid rude comments. In some ways, we think it's a little unfortunate the context that it came up, because it's created an impression that any and everybody can create chaos and be rude at meetings, even if they're in the audience, et cetera. And as we'll talk about a little bit more here, we don't think that's really what the court was intending to say or did say. But because of some of both the language in the SJC's decision, which some of the historical references really did lean in there on how wild some historical meetings were in colonial days in Massachusetts, with lots of very enthusiastic and critical commentary being thrown around. And because of some of that language and concerns about how meetings have been going, some municipalities began talking about eliminating public comments altogether, suggesting that they would now be too chaotic, which we think would just be a horrible result for democracy and free speech both, because of the importance of public officials actually listening to commentary from the people for whom they work about how things are going in their town, including how they think that the boards are managing their work. So in response, we sent out a letter to many cities and towns and the Mass Municipal Lawyers Association, explaining that in light of the court's emphasis on the historical importance of public comment, eliminating such sessions so as to be able to restrict and prevent people from criticizing the board would itself raise constitutional questions. And also addressing why the ruling did not mean that meetings have to be chaotic. And the letter's linked on our website at the site that's listed there. But I thought it might be helpful to go through some of the points that we made, just to try to illuminate why we think meetings do not have to be chaotic and can still honor the free expression rights that are issued in this case. Under the SJC decision, a rule that only people who are recognized by the chair can speak, which is one of the rules in the open meeting law, as well as other provisions there, that For instance, people need to be quiet, like when their time is up, not based on the content of their speech, but when their time is up, are still lawful after the Barron decision, we believe, as long as those rules are applied in a reasonable and content and viewpoint neutral manner. So, for instance, people can be expected to speak only when the chair recognizes them, but if the chair refuses to recognize someone who signed up to speak because he knows what they're going to say and doesn't like it, that would be problematic. But assuming those rules are followed in a neutral way, that's still perfectly lawful. Public comment periods can be for a reasonably limited overall period of time, and really scheduled whenever on the agenda the chair chooses. We made the point in our letter that we think it's good to have them at the beginning of the meeting because a lot of people have other obligations, can't necessarily stay all the way till the end of a public meeting, and opportunities to hear from residents and others will be lost if they're not scheduled then. But in fact, the chair has quite a bit of discretion about deciding when they will be scheduled during the meeting. Individual speakers can still be limited to a certain number of minutes, and that helps ensure that other speakers have time to speak, as well as the fact that the meeting moves along and the board can get to agenda items that they need to deliberate upon. If more individuals seek to speak, then it can be accommodated in the total time allotted for the public comment. The chair can enforce the time limits and say, well, you'll have to come back next time. Or of course, if there's a real interest in hearing from the public, which we hope there is, the body can always move to extend the public comment period on an issue that's really seems important and to be generating a lot of interest. Speakers can still be required to address only matters within the jurisdiction of the body they're in front of. So if they're going, I don't know, to a school committee meeting and start talking about a zoning problem, that can be ruled out of order. That's been clear for a long time that topics can be limited to those within the body's jurisdiction. And there's also discretion to say, some towns say public comment will be on matters that are not on the agenda. Others say public comment is only for items that are on the agenda. We think some combination of those is better because people may want to raise things that are not on the agenda so that they'll get on a future agenda, and that's good for participatory democracy. And while the SJC could perhaps have been a little more clear on this, we think meetings dedicated only to certain topics are still allowed, as long as that is not manipulated so as to keep particular people from expressing particular views. Now, here's one I think that some of the language in the course decision and the following coverage created some confusion about. Members of the audience are not free to interrupt recognized speakers or heckle during the middle of a discussion by members of the public body. And the court's very clear about that right up front in its decision. One recent example, I think, of some confusion about that is that the wonderful columnist Renee Loth just recently wrote a nice piece about civic engagement in Somerville. But at the end of that story, she said something about how in light of the new Supreme Court decision, SJC decision, bodies can't stop people from heckling. And with all due respect to the wonderful Renee Loth, that is not an accurate reading of the SJC decision. It's only people who are recognized to speak during public comment who have a right to finish their time, say their piece, and then sit down. One of the things that comes up is whether or not members of the board should engage in a back and forth with members of the public who are giving public comment. I think there are pros and cons for both things. Many municipal bodies have been concerned if there ends up being a full discussion with members of the board without an item being on the agenda, that would make them in violation of the open meeting law. Which I think there are ways not to have to worry about that, but it's fine to have rules that the members of the body won't respond directly during the meeting. If they are going to respond, it shouldn't come out of the speakers 2 or 3 minutes. Yeah, that's their own time, so they shouldn't take up people's time with, or at least it shouldn't come out of their time if they're going to engage in that dialogue. Again, the Barron decision dealt with speech during public comment periods. Nothing in the decision changes the fact that if there's anyone who, and it's talking about constitutionally protected speech, if someone stands up after being recognized in public comment and makes a true threat of violence or says things to incite the crowd to engage in imminently in unlawful conduct, recognized exceptions to First Amendment and state constitutional protection, they can be directed to cease. And if they persist, they can be ordered to leave consistent with the open meeting law. Physically disruptive or physically threatening conduct can always be forbidden. There have been times in some fraught meetings where there has been threats of violence or people have thrown some things or whatever, that clearly can be prevented, and the Barron decision doesn't do anything to impede that. And then, as the court emphasized, the chair can always request that people be respectful and courteous, and they can model that behavior in terms of treating people who are speaking respectfully and courteously, even if they don't agree with them. And that, we think, does help to set proper tone for these meetings. Since our letter went out, I'm not saying it's all because of our letter, but we have not been hearing a lot of complaints about bodies continuing to threaten to eliminate public comment sessions. There may be some that have reduced them, but we haven't been hearing a big outcry about it. And most seem to be complying with the SJC decision. We've seen several communities that have officially changed their public comment policies to conform, although some have not yet. And just a couple of days ago, I was reviewing a video where a public body was telling a commenter during a public comment period that they could not name specific board members who they were criticizing. And we think that is not consistent with the SJC decision, which is full of language about become a public official. Part of the obligation of the office is to be able to receive criticism without overreacting, and along with any praise you might receive. So, I mean, the takeaway is we think that the Barron decision is a really historically important decision that might have effect in other states in terms of how other states are interpreting their constitutions, and even on with the Supreme Court trying to resolve some of these issues about what kind of forum they think public comment periods are, and then how much protection there is for free speech in there. And we think this is so important because even though there's lots of social media and other ways to communicate with public officials, we think there's no real replacement for being able to stand face to face, either as we are now remotely or in person at a podium, and in order to be able to share one's views with one's public officials. And it's also a way to educate your fellow citizens. You know, you may not know about an issue until you hear one of your neighbors raise it. And that's just we think the whole system is a very important piece of a representative democracy. If people do hear about people experience not being able to make comment consistent with the principles that we've talked about here today. There's a few things they can do. They can contact our office and get in touch with our, call our main number, and we have volunteers that take calls where people are seeking legal assistance, and we'll process that as we can. The Attorney General Civil Rights Division is another place that people can contact if they feel like their free expression rights are being violated. I neglected to put on here, but Pioneer Legal is also interested in helping people who may experience problems in public comment sessions. And of course, people can seek private counsel, including through the Mass Bar referral line, because I think quite a few people are interested in trying to ensure that these rights are protected. And I'm happy to have some discussion if that would be useful.
All right, looks like we do have one question from Brett, and who asks, what is your or the ACLU's position on so-called, quote, civility pledges, unquote, encouraging public commenters to engage in respectful discourse, which appear intended to be aspirational in nature rather than having the force of law?
Well, I think, as I said before, that we think that certainly a chair can, at the beginning of the session, ask people to be respectful. I mean, the Superior Court here basically said that what Southborough had was a civility code, and that could be enforced. And so if that's what we're talking about, something that's enforceable, someone takes the pledge, and therefore you know, they can't say anything that the chair might deem hurts his feelings or rude or whatever, that wouldn't be lawful. But as the SJC explicitly said in its decision, certainly civility and respect can be requested and modeled by the members of the board.
Ruth Bourquin from the ACLU, thank you so much.
Yeah.
This was a great overview, and especially involving a very timely case.
I really want to recommend that if people have not actually read this decision, to go read it, including the chunk that just talks about the long history of town meetings in Massachusetts, dating back to pre-colonial days, really. And it's just sort of a beautiful through line to how our history can still inform our present and create what we think are good things.
That's excellent. I'm a huge history buff, so I'm definitely going to be checking it out for sure. And I want to thank everybody who tuned in, to everybody in our live audience. And I encourage everybody to check out our previous episodes on NEFAC's website and our YouTube channel. Ruth, thank you so much for this great presentation. And I hope everybody can join us again next time.
Thank you all.
Take care.
See you, Emily.